The Illinois Supreme Court being asked to take up the case out of Madison County where a judge declared a state law limiting where people can sue the state alleging constitutional violations can file their lawsuits to just Cook and Sangamon County, not any of the other 102 counties across the state. We've talked about this for quite some time since it was passed last year and signed into law. And even whenever it was challenged in court on a variety of different cases, the one down in Madison County dealing with the firearm industry liability law that the state signed separately. But when the state motioned to move that from Madison County to Sangamon County, the plaintiffs said no and got a judge to rule that that state law limiting venues is illegal, unconstitutional as applied. Well, now the state has taken it directly to the Illinois Supreme Court. Welcome back, Bishop on Air. I'm your host, Greg Bishop. Thanks for hanging out with me each and every weekday morning. Be sure to like, subscribe, and hit that notification bell. And let's get right on into this story where you've got, if you look at the Illinois Supreme Court's website, you'll see, just search yourself and you can find these things. Appreciate showing you guys how to do this yourself as well if you've got time. But if you go to the Illinois Supreme Court website, illinoiscourts.gov. There you'll see high-profile cases, Supreme Court high-profile cases. You view that, you click through, and then you find high-profile Supreme Court cases. And filed yesterday, Piasaw Armory versus Kwame Raoul, etc. So, again, the background here is about a year ago. It was last summer, actually. You had the governor, JB Pritzker, in the state of Illinois. He signed that law that ultimately would mean you cannot sue the state outside of Cook County or out of Sangamon County. So you can only file lawsuits there. You can't go to any of the other counties, Madison County, Logan, whatever county. Any of them across the state, except for Sangamon and Cook, right? There's 102 counties across the state. They each have their own district courts and local judges that are of the people there, and they get appointed and elected and retained. Court in your backyard you can take a case to, but not under this law. If you're challenging a state law for constitutional reasons, then state law says, and this law was signed by the governor last year, it says that you cannot sue the state for constitutional violations in the venue of wherever you're at. No, you have to go to Cook County or Sangamon County. And travel, I'm sure, is burdensome for those who can't make it. But the governor signed the bill in June of last year, and he was recently asked about this. We'll touch on that and revisit. The proponents ultimately said that they wanted this law because there were lots of constitutional challenges for things like executive orders during COVID, the masking, the vaccines, the social distancing, especially how it impacted schools with teachers and parents and students. So you had a lot of cases there, but you also had all the cases challenging the state's gun and magazine ban in various counties. If you recall, there were temporary restraining orders into the thousands with local judges saying that the law likely violates the Constitution and issued temporary restraining orders. Of course, when it got to the Illinois Supreme Court, that ultimately did away with a lot of those cases, but clearly still questions about the ability to hold the state accountable for questionable laws that people allege violate their rights. But when they passed this, you had Republicans saying that this was tyrannical, right? The proponents said we need this because of judicial economy. We want to make sure that the Illinois Attorney General, which is a separate elected constitutional officer from the governor, but apparently the Attorney General is fine defending the governor's actions, signing laws that people challenge. So Illinois Attorney General being right there to defend those things in court. He's got limited resources. So the proponents of this bill say, hey, we need to be able to just focus on Sangamon or Cook County with these lawsuits, not having them travel all over the state. But flashing back to whenever this ultimately passed the Senate, you had State Senator Jason Plummer raise substantial concerns for the citizens of Illinois. Here's just some of what he had to say.
This is offensive to the people of Illinois. And with all due respect to the president, I think some people in this body are starting to forget who works for who. The judiciary does not work for the legislature. The legislature does not work for the constitutional officers. And the judiciary and the legislature and the constitutional officers work for the people of Illinois. And it's time that you start showing some respect to the people of Illinois, quit limiting their rights, quit taking their rights away, and frankly, when we take their rights away, at least give them the decency and the respect to allow their concerns about their rights being taken away be heard in a local courthouse. This is an affront to democracy. I urge a no vote.
So again, just some of the debate that happened back last summer, and then the governor signs it, and it's enacted, and then you had challenges even filed in federal court. But one in Madison County State Courts, you had a challenge of a separate law, the firearms liability law, the firearm industry liability law, that essentially says, you know, the attorney general can go after the firearms industry for how they advertise. So Piasaw Armory, they sued against that law in Madison County. The state requested that they move that from Madison County to Sangamon County, even after the attorney in the case for the plaintiffs, Thomas Magg, said, I dare the state to try to move that case. Well, the state tried to move that case, and then they challenged that, said, no, we don't want that to be moved. This law is unconstitutional. Then we saw, as we reported out last week, earlier this month, a Madison County judge essentially said that that law was unconstitutional as applied. So let's go through this again, just a little bit of background. You have this law that was passed, House Bill 3062. Republicans said it was tyrannical. You had Piasaw Armory challenge the firearm liability law. And Madison County judge found that the court venue limit law, as applied, was unconstitutional. So moving on here, you've got the arguments that were made. The state tried to argue that this is to limit venue shopping, and if the plaintiffs can't make it to Sangamon County, they can zoom in. Well, the judge fired back and said the same goes for the state. If they can't make it down to Madison County for hearings, well, they can zoom in. So interesting to see that, and the judge ultimately finding that unconstitutional as applied in the Piasaw case. Well, last week, my colleague Katrina Peterson attended a news conference with the governor on an unrelated issue, and she was able to ask the governor a question about, well, your reaction to this particular law being found unconstitutional by the Madison County District Court.
Well, first, let's characterize it properly. It's our law in the state of Illinois, and you know, my reaction is it'll obviously run through the court system. I signed it. You know, I think it's something that makes sense for just organizing the court system, so there's a lot of venue shopping going on by people who are just trying to find a friendly judge here or there. The experts that are, you know, in the two venues that have been designated seem like they have handled constitutional related cases more than any others, and so it makes sense to me to have those cases run through those.
So he says it's going to work through the courts. So after that Madison County ruling, you had the Senate Minority Leader John Curran issue this statement: court ruling should be a warning to Governor Pritzker to stop with the power grabs. The Illinois Senate Republican leader John Curran released the following statement in response to this week's ruling, linking to the Center Square article, that Governor JB Pritzker's law that limits individuals challenging the validity of state law in court to be unconstitutional. Curran said this is the second bill that Governor Pritzker has signed into law over the last year that the courts have already found to be unconstitutional. As we get further along in this legislative session, this ruling should be a caution sign for the governor and the legislature to stop with the power grabs that seek to suppress the constitutional rights of Illinois citizens. So what was the other law? You guys might think, well, it was the gun ban. Well, that's still working through the courts. And you got the Southern District Federal Court moving forward in an expedited manner to get to the merits of the gun ban challenge. But if you recall, there was another law that the governor signed dealing with crisis pregnancy centers and allowing for the attorney general to go after crisis pregnancy centers that don't say abortion's an option for an individual who is in a crisis pregnancy. So, you know, a lot of pro-life groups said that they didn't like this law because it was an infringement on free speech. When it was brought up in federal court, a federal judge said something to the effect of, this law is stupid and likely very unconstitutional. And then you had the state essentially say they're not going to be enforcing that. So I think that that's the other law that that was declared unconstitutional that they ultimately stopped. But this one in particular, you've got the state going to the Illinois Supreme Court to try to defend the venue limit law. Hopefully you guys are able to kind of follow along with this, because it does get convoluted. Following this stuff is always, it's Kafka-esque. Which means, around every corner, there's 15 different corners that could possibly get you trapped in, and just like a weird maze, right? So, but I think it's important that you do, track what's happening here, especially in the context of everything else we've talked about, including at the Illinois Supreme Court and conflicts of interest. So let's go to the Illinois Supreme Court site here and take a look at what they've got. The latest filing here, appellant's notice of appeal accompanied by Madison County Circuit Court order. You click on that and you can see that the state is spelling out essentially where they're at in this case. They say, please take note that under Illinois Supreme Court rules, defendant Kwame Raoul in his official capacity as Attorney General of Illinois, by and through his attorney, hereby appeals directly to the Illinois Supreme Court from the partial final judgment entered March 4th by Judge Ronald Foster down in the Circuit Court of Madison County. In this case, granting plaintiff summary judgment on the claim that the section of the law violates the United States Constitution due process clause as applied to persons who reside or were injured outside of Cook or Sangamon County. They say that their rule and the request for direct appeal, not going from the district court to the appellate court, but going from the district court straight to the Illinois Supreme Court, is satisfied because the circuit court entered a final judgment as to one or more of fewer than all of the plaintiff's claims, namely count 5 of plaintiff's complaints, which challenges the law on due process grounds, and the circuit courts made an express finding that there is no just reason to delay appeal. So by that, they file their appeal to the Illinois Supreme Court directly. But then you had the appellees, the plaintiffs in this case, as represented by Thomas Magg, also file. And they ultimately spell out here that they're filing their appeal because the defendants submitted a notice of cross appeal of the order of the trial court dated March 4th. And Calkins v. Pritzker is instructed to cross appeals from the denial by the trial court of plaintiffs' arguments related to the 3 readings rule of the Illinois Constitution in order to preserve the arguments on appeal and respectively request the honorable court reverse the trial courts to the extent that it found the law, also known as HB 3062, did not violate the 3 readings rule of the Illinois Constitution, and in said process hold said unconstitutional in its entirety as opposed to merely as applied, and as such overrule such precedents in various other court precedents, and in the process affirm the ultimate ruling of the trial courts in this case denying said motion to transfer and other relief previously appealed by defendants by reversing and vacating the challenge based on the 3 readings rule. So they filed their quick response here yesterday. So clearly the Illinois Supreme Court is going to be handling this case. But the case involves a law that Governor JB Pritzker signed. And then I imagine you'll have the can of worms opening of the question of, court integrity and conflicts of interest, because you've got 2 Illinois Supreme Court justices who, as candidates for the job, received $1 million each from Governor Pritzker, let alone the 6 figures they received from members of the legislative branch, leaders of the legislative branch, the House Speaker and the Senate President. So there's going to be that ongoing question. Interested to see if Thomas Magg files for a motion for the 2 justices to recuse themselves. Because the issue of recusal, we'll have to revisit again. There was another case involving recusal where, Ed Burke, who I believe was found guilty of corruption up in Chicago, and there was recusal of stripping his law license. So some of the headlines just seeing in passing out of that particular saga. So interesting to see where we're at here. Clearly, this is going to be a developing story. We'll watch as this progresses, and we may even touch base with State Senator John Curran, the minority leader in the state Senate, to get his thoughts. But clearly, this is going to be working through the process. even as Governor JB Pritzker said. So there you go. It's the latest on the venue limit law that was signed and challenged, and now apparently it's going to the Illinois Supreme Court. Fascinating. It's Bishop on Air. Like, subscribe, hit that notification bell.